for such offense to include certain expenses. And with that, then a brief from our revisor.
All right. Thank you, Madam Chair. Good morning, committee. Jason Thompson, Office of Revisor of Statutes. You have House Bill 2583 and a bill brief in your packet. It does come to you as amended by House Committee. For that procedural background, I will let you know it was requested in the House Committee, or actually it was sponsored individually by Speaker Hawkins and Chairperson Owens. It was then referred to the Committee on Corrections and Juvenile Justice. They amended the bill, passed it out to the floor, and on final action, the House passed the amended version 107-4, and it finds its way here to you today. The bill itself, as the chair mentioned, increases the criminal penalties for harming or killing certain dogs and horses, and also deals with restitution for those offenses. Section 1 amends the crime of inflicting harm, disability, or death to a police dog, arson dog, assistance dog, game warden dog, or search and rescue dog. It's found in KSA 21-6416. The first amendment I'll mention to the bill, to the crime, is to include police horses. So you'll see several places where police horse is added, and then that term is defined consistent with the other animals that are defined in the statute. The current penalty for violations of this statute is that it's a non-grid, non-person felony. So any time served incarcerated is served in the county jail. So it is a felony, but it's served at the county jail, not at a state correctional facility. That's the non-grid felonies. And we only have a few of those. DUI used to be one, for example. It's not anymore. But this is one of those non-grid, non-person felonies. The sentence is not less than 30 days nor more than 1 year of imprisonment, and a fine of not less than $500 nor more than $5,000. And then you also have to have a psychological evaluation to assist the court in determining your conditions of probation, and you must complete an anger management program if you're convicted of this crime. So the House Committee on Corrections and Juvenile Justice amended the bill to provide that the current penalties will remain in place for any harm to an assistance dog. So there's no change to the crime related to assistance dogs or to the penalties for harming an assistance dog. The bill also, as introduced and as in front of you, maintains the current penalties for harm that does not result in disability or death to one of the special animals that's defined, a police dog, an arson dog, police horse. So those penalties for harm that does not result in disability also unchanged from current law. The changes are for harm that results in disability or death to one of the special defined animals. The penalty would become a severity level 4 non-person felony. So rather than being a non-grid, non-person felony, they would be on the grid at a level 4 non-person felony. For harm that results in disability or death to one of these special defined animals during the commission of fleeing or attempting to elude, interference with law enforcement, or escape or aggravated escape from custody, the penalty would be a severity level 3 non-person felony. So you get a level 4 for disability or death to one of these special animals, and you get a level 3 if that occurs in the course of one of those specified crimes I just mentioned. For all those offenses, 90 days of mandatory imprisonment would be imposed and a mandatory minimum fine of $10,000. You're still subject to the psychological evaluation and anger management requirements that were described already. And then the second aspect of the bill is restitution. The amendments are to KSA 21-6604. That is our criminal code statute about restitution. It specifies that violation of the crime 21-6416 will include restitution for the cost of veterinary medical treatment, reasonable funeral and burial expenses, and replacement of the animal. And then the House Committee added a provision that replacement costs shall include but not be limited to training costs, personnel expenses, and costs associated with boarding the animal during training. So essentially, replacing the animal with another animal that can do the same job. All of those costs would be included as part of the restitution, to put it kind of a different way. The last thing I'll say is that the bill will become effective on July 1st on publication in the statute book, and I'll be happy to answer questions.
Thank you. Committee questions. We have a Sentencing Commission analysis here, and a fiscal note, and the Sentencing Commission talks about may increase prison admissions, but I thought the bill has only to do with county jails. So do you have any information about that?
Madam Chair, excellent question. So for the crimes that are not changed, those are non-grid, non-person felonies. They remain non-grid, non-person felonies. But the two new penalty provisions for the death or disability to one of the special defined animals, or death or disability to one of those animals during the commission of one of those specified offenses, those become on-grid level 4 and level 3 offenses. Because there were 0 convictions for this crime, the commission says there's likely to be no impact there. And so I think that's why you have kind of a potential impact on the prison system, but they can't specify anything for certain. You can see in their findings there that there was 1 arrest for violation of this statute and 0 convictions for this statute in 2023. So if you were to have more arrests, convictions for it, the penalty would be higher under these certain circumstances, and they would be serving prison sentences, not jail sentences. But at this point, they're not anticipating any substantial numbers of convictions, I suppose.
And maybe you can't answer this right now, but with some research, is it a level 3 or a level 4? It wouldn't be a non-person felony if you assault someone criminally and you cause them, I guess, disability or death wouldn't be assault. That would be homicide. And are these non-person felony severity levels 3 and 4, are they higher or lower than the same similar sort of conduct that a person would commit against another person? And I'm thinking it's different because these are non-person felonies by definition.
Madam Chair, another excellent question. And yes, so that would be the main distinction. These would be non-person felonies because it's not a person. The others are person felonies. But as far as the level of severity, I have the analysis from the Sentencing Commission that we can refer to, and then I have a little bit of work I did in advance because you told me we might talk about this, so I appreciate the, the heads up. So in the Sentencing Commission analysis, they give you some comparable offenses on page 3. So you can see that the knowingly but not maliciously killing or injuring an animal first conviction under 2164.12, that's a Class A misdemeanor. Involuntary manslaughter in the commission of a DUI with a victim under 6, that's a severity level 3. That's the second one there. Inflicting harm that results in disability or death to one of these specified animals, that's the new provision that's in bold there. That would be a level 3. Involuntary manslaughter related to DUI is a level 4. And then there's the level 4 right below that for inflicting harm that results in disability or death to a police dog, et cetera. That's the new crime here. Battery, just simple battery of a city or county correctional officer, that's a 5. And then they gave you a couple others, dogfighting and cruelty to animals, that are a 10, and a non-grid, non-person felony, just like the current law. But because you asked to specifically look at battery, which is bodily harm to a person, the current law on battery of correctional officers, employees of a city or county, that's the one the Sentencing Commission referenced there.
So that's a less severe crime than what the bill
5.
proposes.
Right. So the one referenced by the commission there, that's a severity level 5. That's battery of a city or county correctional facility by a person confined in that facility. Knowing or reckless bodily harm to a law enforcement officer in that same statute, 2154.13, is a severity level 7. But then you increase those penalties when you get to sort of greater bodily harm. So the comparable one for aggravated battery against a law enforcement officer, which is knowingly causing great bodily harm to another person or disfigurement of another person, that's a severity level 3. So if you kind of translated that, great bodily harm to the animal here would be a 4, and that of an officer is a 3. And the 4 here could become a 3 if it's done in the commission of certain other crimes. So it could be equal but not greater than. So just those are just a couple examples. If you look over at the aggravated battery of a law enforcement officer, there are severity level 3s and severity level 4s over there. And I think the idea might have been to make these a similar level, except they're non-person instead of person. So hopefully that gets to your question.
It does. So if you could just clarify that, I'm looking at the grid in page 3 of the Sentencing Commission's report. So it looks like the grid that the bold part there, 21-6416, that inflicting harm that results in disability or death to a police dog, arson dog, assistance dog, and other dogs or horses during the commission or fleeing or attempting to elude a police officer is a severity level 3 non-person, but then involuntary manslaughter in the commission, attempted commission, or flight from DUI is a step below that, a severity level 4. Do I have that correct?
Madam Chair, that's correct. And part of the reason for that, legislatively, you have different culpability terms. So this is knowingly causing harm, and the involuntary manslaughter DUI is recklessly causing harm. So that's part of the reason potentially for the difference. But yes, that is correct. 3 and 4 are the penalties there.
Okay, thank you. Any other questions for the revisor? Yes, Senator Gossage and then Senator Haley.
Thank you, Madam Chair. Just very quickly, in Jason on the revisor of statutes, I'm looking at paragraph 3. It says the House Committee on Corrections and Juvenile Justice submitted the bill to provide that this penalty will remain the same for any harm to an assistance dog. But then on page 1 of the actual bill, the assistance dog has been stricken 3 times.
Madam Chair and Senator, great question. The strike of assistance dog in the new language, so say line 31 and line 35, is to make sure that the new penalties, the higher penalties, do not apply to assistance dogs. So by moving them back up to the bold language in lines 16 and 17, this preserves the current penalty for inflicting harm, disability, or death to an assistance dog, or inflicting harm that does not result in disability or death to one of these special animals that's defined in the bill.
That makes sense. Thank you very much. Thank you, Madam Chair.
Thank you. Senator Haley.
Madam Chair, and thank you, Mr. Thompson, for the review. And I just want to get to just a plain meaning, clear question that, again, I know we have several proponents, but I probably know what their answer would be. In your interpretation of this before us, in a scenario where a police dog is set up on a suspect and the police dog engages with the suspect and certainly jumps on and is trying to pull him down, and the suspect injures the dog in a self-defensive manner. Many people are afraid of dogs, especially, and in the interpretation of this bill, if that suspect were to, in a self-defensive move, injure or even kill the attacking dog, then this would be applied. I pretty much think I know the answer, but that's kind of my concern. Would that be a fair assessment of the peanut or the kernel of what that part of the bill would do?
Madam Chair and Senator, I'm going to just direct you back to the elements of the crime, which is just subsection A. So for this section to apply at all, you have to inflict harm, disability, or death to one of these animals knowingly and without lawful cause or justification. And so that's the entryway to the crime. And then the penalties depend on what kind of harm you caused and what you were doing when you caused that harm. So if you caused the harm while fleeing and eluding or doing other conduct that's specified there in the severity level 3 penalty, you get that enhanced penalty. If you cause harm that causes disability or death to one of those special defined animals, you could face a severity level 4 penalty. But if you cause harm that's not disability or death, or you cause harm to an assistance dog that's not one of the other special kinds of dogs, you're still looking at the non-grid, non-person felony that you face under current law. So it does have to be knowingly. It does have to be without lawful cause and justification. It does have to result in harm, and then depending on the harm and what you did, that's when the penalties would apply to you. These level 4s and level 3s. So maybe is my answer to your specific scenario.
And
it really depends on those facts.
I know we have some conferees, Madam Chair. Very briefly, if a dog were, in self-defense from someone who was set upon, if a dog were injured, then all of this would apply. If somebody were fleeing and eluding, and the dog was set upon that fleeing and eluding suspect, and in a defensive, purely self-defensive measure, the dog would be knowingly in the heat of the activity injured, choked or struck or whatever, then this would apply. I mean, then there would be the ensuing penalties because it was in the commission of fleeing or attempting to elude a police officer. Yeah, I just
if the elements we talked about are met, if it inflicts a certain amount of harm, up to and including disability or death, then yes, then you could be prosecuted for these higher penalties.
And self-defense would be off the table in terms of, I know we're going well beyond the bill, but
that might require a little bit more of an analysis from a defense lawyer just to make sure I don't misstate something. But there are degrees of defending yourself when encountering law enforcement, and that's different than defending yourself against another non-law enforcement person. So it gets a little more complicated.
Thank you so much, Mr. Thompson. And Madam Chair, if I might remind the committee that I was the big advocate of what is now known as Scruffy's Law that created the felony for cruelty to animals, which Mr. Thompson helped me craft way back when. So I am very mindful of treating our animals with respect and care and concern as well. But on balance, I do have some concerns about some of the underlying principles that might be found in this bill regarding self-defense. Thank you, Madam Chair, and thank you, Mr. Thompson.
Thank you. And we do have some conferees, and we can revisit questions with Revisor at a later time today, but want to get to our first proponent conferee who has some business on the House floor coming up in a minute. They're about to probably gavel in very shortly. And our first proponent conferee, then we will invite Timothy Johnson, Kansas representative for the 38th District. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, committee members. Yes, I'm Tim Johnson, Leavenworth, a little bit of Wyandotte County. Retired law enforcement. I'm very proud to still be a member of the Kansas Sheriff Association. And I'm going to let you read my notes, but I wanted to bring up the issue on the mounted patrol, the horses. You're going to hear from some officers that have worked with canines. These guys are great. I'm certified scent dog handler from back in the day. Well, one of the things that we wanted to add to this bill was that we not leave off that tool of mounted patrol. Police horses, clearly they're not used in the same way we once did. But they have a wonderful place in the criminal justice system. We know at the federal level, in the parks and recreation, the mounted patrol serves a variety of capacities. And they are an excellent tool. But one of the things you need to understand is that in the two agencies I've worked with for a number of years, the horses that we utilized belong to the officers. They use and bring their own horses. Some of them are donated. One of the standards is looking for mounts for your patrol is to get them donated. You also form a very close bond. Now, we go through a lot of training. I have trained both in St. Louis and down in Houston. And one of the things that we've learned that the horse provides certain visual sightings to people. They are an incredible public relations tool when used in parks and recreation. But they are they're not always cost effective, and that's why our numbers are down. I do know that in Wichita, they have a wonderful unit. I had visited there many years ago. But there's many techniques that we learned and work with to make sure that riding our mount, we are protecting that animal as well as not using it in a way to just injure people. There are not techniques that are used to punish. They are used for visibility and other issues. But there's a bond. There's a bond with that animal. I swear there were days when I could go out and talk to a horse and I just felt better. I maybe they just understood me, or maybe I reflected on the right. I don't know. They listen a lot better than my wife, but there's something about that. And to know your animal has been injured. And we know in training, certain techniques were taught to people, especially back east. Ways that you would pull the horse to the ground by grabbing at the front, or to come from behind and attempt to push a leg out, or different things. And there are ways that those mounts can be injured, and it can be very costly, and in fact can put them completely out of service. So when that was included into this bill, I wanted to let people know that that is just as important as what you're going to hear about these canines. And with that, I would stand for any questions.
Thank you. Committee, any questions? Senator Haley.
Thank you, Madam Chair, and I recognize Representative Johnson has to go, and thank you for your testimony, Representative. To your knowledge and your extensive years, many years that you've spent in this, and thank you for your service in that regard, have any horses been intentionally injured by someone on the other side of the law, or potentially on the other side of the law? Have you
Yes.
seen horses that have been?
And I worked in Wyandotte County when we had our Sheriff's Department mounted patrol. We had an issue with a vehicle. We were using them in those vehicle checkpoints back in longer than I'm trying to remember exactly. They took it into the mount to knock it off balance, and that animal was out of action for a while. And so that was that. Some of the other things we do look for, of course, is fireworks. People will use large fireworks, throw them under the mount towards it, trying to frighten it. There's a variety of things, but in my experience, and I would share with you, if there was a way for us to maybe bring it back in Wyandotte County out at our new beautiful facility for the American Royal,
Yes.
What a place for us to have animals there for security, much like they do in Houston at the stockyards and at the St. Louis Zoo that goes down there. I'd just like to see it back in our county if I could ever help with that, sir.
Thank you, sir. And thank you for your insight on this. Thank you, Representative Johnson and Madam Chair.
Thank you. Other questions? Not seeing any. Thank you for your testimony today. Appreciate it. Committee and conferees, we do have 5 other proponent in-person conferees. I would ask that you please not duplicate each other's testimony, and we will limit testimony to 2 minutes each, please. And with that, then, we will hear from Sergeant Ryan Sumner, Lenexa Police Department, on behalf of the Kansas Peace Officers Association. Please introduce yourself and welcome to committee. Can we make sure your microphone is on?
There we go. Sorry about that.
Thank you.
Thank you, Madam Chair and committee members. I'm thankful to get a chance to come up here and talk on the behalf of the Kansas Peace Officers Association, and we're in here in support of Bill 2583. I've been employed with the city of Lenexa for a little over 20 years. I was a canine handler for 16 years. I handled 3 dual-purpose dogs, trained in narcotics and patrol. I was a regional director over National Police Canine Association for a little over a decade, and the training director now, and had 13 states in my region and about 300 dogs in my region. So I have a lot of experience with police dogs all over the Midwest. Been to several police dog funerals where dogs have been killed in the line of duty. Just have a vast amount of knowledge. Easily, these dogs are one of the most important tools an agency can purchase. We use them for a number of different things: narcotics, explosives, search and rescue, comfort, cadaver, etc., apprehension. Their noses, hearing, night vision, speed are superior to humans. They're courageous, loyal, and do all the above tasks for just a pat on the head or good boy, good girl. They're a great tool to us. They save citizens and police officers' lives daily, searching for suspects that have committed violent crimes that may be running in your neighborhood, missing elderly, missing children, all of the above. I have approximately 1,000 deployments and a lot of stories about my dogs apprehending really bad people and also finding really good people that needed help. These dogs are used to search some of the venues that you take your families to, like the Chiefs Stadium, the Royals Stadium. All those areas are swept before you take your family in there to make sure there's not explosives and that kind of stuff in there. They're valued by their agencies who procure them, the officers who rely on them, the handlers who handle them, the citizens who they serve to keep them safe, and the families that adore them when they go home. Unfortunately, with going to those police funerals, the part that I do see when we're in line driving through, St. Joe, Kansas City, Missouri, all the areas that I certify, all the citizens, thousands of citizens stand on the side of the road in support of the police dogs. Talk a little bit about the financial side of things. And you
Well,
see
we're at the 2 minutes and over. So is it in your testimony? Could you direct us where in your testimony the financial side of things is? And we can take a look at it there and
it is in my testimony.
hear from other conferees. Apologize, but please stand by for questions because there might be questions for you when we've heard from all the conferees.
Okay.
Thank you,
very
Sergeant.
much.
Appreciate it. And next, we will hear from Sheriff Jeff Easter, Sedgwick County, on behalf of the Kansas Sheriff's Association, Kansas Association of Chiefs of Police. With that, please introduce yourself and welcome to committee.
Good morning, Chairwoman Warren and committee members. I'll keep this very brief. The thing that I do want to point out is the gentleman that spoke before the revisor explained very well what this bill does. And the new section, which is Section C, subsection 1, identifies the crime as a level 4 non-person felony, which is a change from the current statute. The other change is in subsection 2 of Section C, which then talks about the aggravated escape, those type of things, and causing disability or death, which then now makes that a level 3 non-person felony. We have a deputy that we'll talk to you about our K9, which was the latest one killed. If in respect to Senator Haley's question, that particular case, the individual was charged with the current statute as it is, which is a level 5 non-person felony. In respect to your question on could they use self-defense, in my 35 years in law enforcement, any of those type of cases, murder, manslaughter, and in this case, self-defense would be a defense the defense attorney would use in case that was something you had for one of us. So with that, I'll stand for any questions. Thank you.
Thank you, Sheriff. Appreciate it. Next, we will hear from Sergeant Ben Jonker, Kansas State Lodge Fraternal Order of Police. Please introduce yourself and welcome to committee.
Good morning, Madam Chair Warren and members of the committee. Thank you for allowing me to testify in support of House Bill 2583. I am Sergeant Ben Jonker. I've been with the Wichita Police Department for 23 years and a K9 supervisor for 9 years. You all have my written testimony, so I'd like to tell you a story about 2 dogs that were special to me. First was K9 Rooster, and his end of watch was March 18th of 2017. Rooster was partnered with Officer Daniel Gum. On March 18th of 2017, officers responded to a felony domestic violence call where an individual had threatened several individuals with a firearm. Officer Gum and Rooster responded with several other officers and set up a perimeter around the house. The suspect exited and when confronted by officers attempted to flee back inside the house. So Officer Gum deployed Rooster to try and apprehend the suspect. The dog did apprehend him, and the suspect produced a firearm, shooting and killing Rooster. Rooster was 7 when he was shot and killed, and he was the most experienced canine that we had on the department at that time. We replaced Rooster with canine Bane. Bane was partnered with Gum for several years, and he was a very strong dog. Officer Gum passed away from cancer in 2022, and we gave Bane to the Sedgwick County Sheriff's Department. On November 16th of 23, Bane was deployed into a drainage tunnel to apprehend a violent felony suspect. During this apprehension, we believe that the suspect kicked Bane so hard that it fractured his liver, causing him to start to bleed internally, getting weak, and then that there's evidence that the suspect then strangled the dog. As a canine community, we were stunned that the harshest sentence that this suspect would get was just a year in jail. It cost us between $8,000 and $10,000 to purchase a green dog. After training, we estimate that the dog would be worth somewhere between $30,000 and $40,000. As some of the questions have been brought up, we only deploy these dogs in very serious situations. This isn't something that we're deploying on shoplifting suspects. They're violent felony suspects. We're very cautious on when we deploy these dogs. We utilize these dogs. They're a huge community asset. The community loves the dogs. So with that, I'll stand for any questions.
Thank you. Appreciate that, Sergeant. Thank you very much. Next, we will hear from Deputy Tyler Brooks, Kansas State Lodge Fraternal Order of Police. Please introduce yourself and welcome to committee.
Good morning, Madam Chair, Warren, and committee members. Thank you for allowing me to testify today. I'm here on behalf of the State Lodge Fraternal Order of Police. I'm currently a deputy with the Sedgwick County Sheriff's Office. I've been in that capacity since 2013. I've been with our canine unit since 2018. I'm currently serving as our trainer for our dogs. My job as a trainer is to train not only the dogs but the handlers and ensure that our dogs are being deployed in the proper way to meet both Supreme Court case law and policies within our department. During my time in the canine unit, I've worked with several dogs, and the most recent dog that I've worked with was police service dog Bane, who you just heard testimony about before. I was with police service dog Bane the day that he was killed in the storm drain, and I would just like to give you another perspective on what we use these dogs for. There's been some questions that have come up already about how we deploy our dogs and what we deploy them for. I'd like to give you another perspective on another aspect of what we do use these dogs for. They're amazing animals, and they serve our law enforcement departments as an invaluable resource to detect crimes, locate people, and save lives. One such instance, which I'd like to direct you to, is a deployment which I had with Bane in the spring of 2023. An armed suspect was surrounded and said he was going to force us to use lethal force on him. He was experiencing a mental crisis and had committed a violent felony just prior to our arrival. Many times we deal with people who cannot think rationally in the moment due to crisis that they are experiencing. Oftentimes these suspects attempt to force us to end their lives by threatening force against us if we get close to them. On this such occasion, I was able to deploy Bane to apprehend the suspect and drag him away from the knife, which kept us from using any kind of lethal force against him. Following the deployment and getting him into custody, I was actually thanked by the man's family for saving his life. That may be an aspect of using these dogs that you may not consider, because they truly are life-saving measures. They're not just to detect drugs or to apprehend people that are running from us. A lot of times they are life-saving measures. As you heard, Bane was killed on November 16th. That also had a very big impact on me and my family. Bane was the type of dog that I was able to socialize with my children. My oldest, who is autistic, was actually deathly afraid of dogs prior to me being partnered with Bane. Through my time with Bane, he became socialized with Bane, and now he's no longer afraid of dogs. We use these dogs for public demonstrations. We bring them in schools. They interact with kids. And I've seen on more than one occasion where a child that was afraid of dogs became less afraid of dogs because we were able to bring those dogs and give them a good experience. So
Thank you, Deputy, for your testimony. Appreciate it.
thank you very
And
much.
if you'll stand for questions at the appropriate time, that'd be great too.
Sure.
Thank you. And next we will hear from Sergeant Ed Brower, Kansas State Lodge Fraternal Order of Police. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Thank you, committee, for allowing me to testify in reference to House Bill 2583 and testify on behalf of the Kansas State Lodge Fraternal Order of Police. I've been in law enforcement for 32 years. 20 years of that, I've been the commander of the mounted unit for the Wichita Police Department, where I've been responsible for the training of all the horses, selection of the horses, as well as selection and training for the animals for the Wichita Police Department. The mounted unit is a supplemental unit used at special events like River Festival or concerts down at Intrust Arena. Wichita is lucky enough to have an old town entertainment district with a lot of restaurants, bars, sports bars, things like that. So in the evenings, Fridays and Saturdays, we're always down there on horseback assisting with crowd management, because when you get a couple thousand people that have consumed some alcohol, sometimes you have some problems. And that's where the horses are a huge advantage. Why horses in law enforcement? Well, we can take the horses in places where we wouldn't want to go as law enforcement officers just because it's dangerous. If I've got 600 people in the middle of Mosley Street there and everything's fine, but a disturbance breaks out of two groups of people, it's pretty easy for me to take my horse, get inside there, and either separate the combatants, or if I need to arrest them, I can do that, and I can do that safely from horseback. And that's the advantage of having a 1,400-pound to 2,000-pound horse that is well-trained, that I can ride through a crowd to make that arrest or stop that disturbance or help the victim that needs to be helped out in that situation. And the police horses, not just any horse works. The vetting process to find a good horse that we use and purchase, it's very expensive, as well as the training procedures to get the horses used to gunfire, fireworks, all the things we do. It takes 6 months to a couple years to fully train a police horse to do all the things that we need to do and do them safely. So that's a huge cost, and that's a huge thing why the civil penalties would help as well if a horse was ever injured by a vehicle or shot or stabbed, and we had to replace that horse. It's anywhere from $5,000 to $8,000 just to purchase a healthy horse, and then all the hours of training that go into that throughout the year, plus the experience in that horse. So yes, I'm a huge proponent of the House Bill 2583, just for the fact of the increased punishment if anybody ever did hurt a horse, as well as the punitive civil damages that would help us to reoccur those costs of purchasing a horse and training a horse. Thank you.
Thank you very much, Sergeant. Appreciate it.
Right.
So are there any other proponent conferees wishing to testify? Oh, yes, sir. Please introduce yourself and welcome to committee, and you'll have some written testimony to present to the committee after. Okay, I'm sorry, I don't see you on our list, but okay, go ahead.
Thank you, Madam Chair. Greg Smith, Special Deputy for Government Affairs, Johnson County Sheriff's Office. You've heard about these animals and why they're so important and the ways that they can help. Our canine unit major concern was with an amendment that was added during the House committee. That amendment is attached to my testimony. We would ask the committee to remove that amendment, basically strike the amendment that was added. Amendment number 2 is what it's referred to in the House. What that does is it restores those assistance animals to the same status as any other canine. Our canine handlers that have assistance dogs, we call them critical incident dogs, are fully qualified law enforcement officers. They're driving around in a marked car. They're responding to calls. Those dogs are there. And those dogs also respond to crime scenes to help us assist with children that may have just witnessed a traumatic event. So they're not always in some safe environment with people. So we're asking that these dogs, which are also a valuable resource and also cost a lot of money to train, are protected at the same way that the other dogs are. And happy to stand for questions at any time.
Thank you. Appreciate it. Any other proponent conferees wishing to testify? Not seeing any, then we'll open it up for questions. Any questions? Senator Haley.
I'm sorry, I didn't track, Madam Chair, to Mr. Smith's, former Senator Smith's last point. I didn't get, did we get a copy of his testimony? Okay. Thank you. I'll find it. I see it for a second. I can get one.
So I have a question about assistance dog for Mr. Smith, and I looked up the definition of assistance dog, and those aren't the police canine dogs, right? I think it says means any guide dog, hearing assistance dog, or service dog, and service dog is defined to mean a dog which has been specially selected, trained, and tested to perform a variety of tasks for persons with disabilities. So are you saying they should be treated the same as the law enforcement
what
dogs?
What we're saying is the definition, which is defined in this bill under the statute of 391113, says assistance dogs and professional therapy dogs. The way that we read that is that could be interpreted that our therapy dogs fall under assistance dogs. So we would rather just have that whole amendment pulled out than to have any kind of confusion like that. I mean, our critical incident dog, Gus, is also being cross-trained for search and rescue. So what category does he fall in? So those are the kinds of things that we're worried about. We'd just like to make that clear that we want those dogs protected as well.
Thank you for the clarification. And then a question just for the proponents regarding the severity level of the crime. The bill proposes to make it a severity level 3 for intentional infliction of, well, actually it just says inflicting harm. It doesn't, or knowingly inflicting great bodily harm, permanent disability, or death, is a higher level criminal penalty than intentionally fleeing from a DUI. And while you're fleeing from a DUI, you commit involuntary manslaughter. So just wondering why the difference. Maybe they could be the same level of severity crime. I certainly think, want to be aware that involuntary manslaughter is you've killed a person. So just wonder why the difference in severity level.
Chairwoman Warren, if you want, I can kind of answer that, but I don't know
Sure.
if you have somebody stepping up to the podium that wants to answer.
There is, but please go ahead and introduce yourself, and he can follow up if needed. Thank you.
Okay, Jeff Easter, representing the Kansas Sheriff's Association and Kansas Associations of Chiefs of Police. As one of the conferees alluded to, we can't deploy canines on misdemeanor crimes. So if you're fleeing from a DUI and it's a misdemeanor crime, it's not allowed. And so, specific to your question, the way I read the statute is what makes it a level 3 non-person felony is that it causes disability or death. What raises from or lowers from a severity level 5 to a 4 speaks to the inflicting harm that does not result in disability or death. And so that's the distinction between the two as I read it. If you just cause harm, it's a severity level 4. If you cause disability or death, then it's a severity level 3 non-person felony.
Am I correct, Mr. Revisor? If you're being convicted of involuntary manslaughter, you've killed a person, correct?
Madam Chair, Jason Thompson, Revisor's Office. Yes, I think under that reckless involuntary manslaughter while DUI, it has to involve the death of a person. That's the manslaughter aspect of it.
Thank you. I'm wondering, is there any objection from the proponents to, as I'm looking at the chart here, moving the inflicting harm that results in disability or death, moving that to a level 4 severity, which happens to be the same level as involuntary manslaughter during flight from a DUI, and then moving down inflicting harm, subsection C2 down to a level 4 and subsection C1 down to a level 5.
Madam Chair Warren, Sergeant Jonker from the Wichita Police Department and State Lodge for Chamorro Police. We would object just because the killing of or injuring of a police dog would be an intentional act. And as you were saying with the DUI stuff, could be recklessly, I think somebody had just described earlier. And as we had mentioned earlier, the things that we're deploying these dogs on, that prevents us from having to go, the actual officers, from having to go into harm's way. So that's why we would like to keep it at the severity level 3.
And thank you for that answer. And in any result, regardless of the mens rea, the intent, in both instances, we have either a harm or death to a dog and then death to a person. That's what we're talking about, is the end result of both of these, right?
Yes, ma'am.
Okay. Thank you. Just some thoughts I'm having as we're looking at this. But anyway, any other questions for our proponents? Not seeing any. So are there any neutral conferees wishing to testify? Not seeing any. Then we will next hear from opponent conferee. Well, she's written only, so please note in your documents, Keisha James, National Police Accountability Project. And with that, I offered there was an opportunity if anyone had further questions for the revisor. Do we have any further questions for the revisor? Not seeing any. Then we will close the hearing on House Bill 2583 and open the hearing on House Bill 2557, expanding the definition of peer support counseling session in the rules of evidence. With that, a brief from the revisor.
All right. Thank you again, Madam Chair. Jason Thompson, Revisor's Office. House Bill 2557 does involve peer support counseling sessions in the Kansas Rules of Evidence. Procedural background, this was requested in the House Committee on Judiciary by Mr. Klump on behalf of the law enforcement associations that he represents. It was heard and worked by the Committee on Judiciary and then passed the House on final action 108 to 12. As mentioned, this involves the peer support counseling exception in the Rules of Evidence, KSA 60-473. Those of you that have been around for a while, this was enacted earlier than I recalled, but 2015, I think, was when it was enacted and last amended in 2019. The current law is basically a privilege related to these peer support counseling sessions. Defines what those sessions are and who's using those sessions, and then gives you a certain privilege with regard to statements made during them and how they're used as evidence, both in the civil code and in the criminal code. The bill changes the definition of peer support counseling sessions, and I won't read that to you. I describe it in the bill and in the bill brief, but it expands that definition to include some different types of settings or communication styles or communication methods. I shouldn't say, not styles, methods, electronic, et cetera. And that new definition would apply to the whole section. There's also amendments related to communications being made are confidential, not disclosed, which is mostly current law there. And then I do mention that these are not public records. They're not open to inspection by the public. And the final thing I mentioned in the bill brief, that those communications are not admissible in judicial proceedings and other court-like proceedings. So again, that's current law, but I wanted to kind of remind you how this would play out. You're defining those sessions, and those sessions then have a privilege that applies to them, and that determines how they might be used or not used in evidence in other matters. Changes would take effect on July 1st if adopted, and I think that's it. I'll stand for questions.
Are there any questions for the revisor? Seeing none, we'll turn to our first conferee, Mr. Greg Smith, Special Deputy Sheriff for the Government Affairs, Johnson County. Please identify yourself and welcome back.
Thank you, Mr. Vice Chair. Greg Smith, Special Deputy for Government Affairs, Johnson County Sheriff's Office. I am a trained peer support specialist. I do these types of counseling sessions with my peers. This bill is extremely important to us because the way the law is defined now, that confidentiality, that privilege is only there if it pertains to a critical incident that occurred on the job. That is not what the majority of the people that I counsel with are coming to me for. They may have marital problems, they may have money problems, may have a myriad of other problems. And we're telling them, because of the way we're trained, this is a privileged counseling session. We can't reveal this to anybody. You know, my sheriff doesn't get to know what I talked about with somebody in a peer support counseling session. The only thing I can divulge is if that person indicates that they want to harm themselves or others, or that they've committed a crime. Other than that, I can't divulge anything. But the law doesn't quite cover it that way, so we want to make sure that those things are there so that we can keep those things privileged, because peer support is a vital part of our department. We have a very vibrant peer support group, and let's face it, there's a lot of crap we see that most people don't see, and it helps to be able to talk to somebody about it that gets it. I'm happy to stand for questions anytime.
Thank you. I think we'll wait and hear from the other conferees. Thank you. We now turn to Lieutenant Alex Taylor, Kansas Highway Patrol. Thank you, Lieutenant, for being here. Please identify yourself.
Thank you, Mr. Vice Chair. This is Lieutenant Alex Taylor with the Kansas Highway Patrol. I oversee our Central Communications Department. I am also a member of the peer support team for the Kansas Highway Patrol, as well as the advisory committee for the Kansas Highway Patrol's peer support team. I'm joined in the back by our director and the major overseeing the program, retired Lieutenant Robert Ware, and I speak on his behalf as well. You have the Colonel's statement already for his written statement regarding his testimony in the bill, and I completely support everything that he's wrote in there. I wanted to come up and speak to you as a chance to offer you a personal perspective on someone that this bill will personally affect. As a peer support member and a peer support team advisory and lead, we often have encounters with people that have experienced critical incidents. However, if you think about all the trauma that you've experienced in your own lives, and how you manage that is by compartmentalization if you don't want to share it with anybody. The brain is only capable of compartmentalizing so much before it spills over into everything else. I like to think of it as a waffle and syrup, the syrup being the trauma that you've experienced and how you manage it. You can only fill up so many squares before you have that critical incident, in which case you take a large squeeze of that syrup and it spills into your life. Nationally, there's approximately 140 officers that take their lives yearly. Not many of those, or not all of those, are because of critical incidents. The trauma that you experience, the amount that you build into a person's ability to cope and handle that, you can't just focus on the one incident. You have to focus on all of the trauma. That includes personal, that includes marital, that includes finances. In the last year, the Kansas Highway Patrol has addressed issues of the following types: job-related issues, supervisory subordinate issues, career issues, emotional and psychiatric issues, fatalities from wrecks, critical issues, financial issues, medical issues, family-related concerns, suicidal issues, and bereavement. A lot of these topics do not have to do with their day in and day out duties. However, as a sworn employee and as an employee of the state of Kansas, for civilians alike, we take the responsibility of taking care of others in an oath to protect and serve. And it's hard to complete those tasks if you are not mentally sound and mentally prepared to serve those. The bill itself could actually use expansion to those supporting groups, such as child advocacy groups that interview children of child abuse or sexual assault that are not necessarily part of a law enforcement agency. I would like to propose that you guys proceed with this bill enhancing the current law. And with that, I will stand for questions.
Thank you. We'll have questions after the last conferee. Thank you for being here. Next, I turn to Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers. I stated those so you wouldn't have to. Thank you. Welcome to the committee.
Thank you, Mr. Vice Chairman. You don't know how much I appreciate that. Our associations actually initiated this bill in support of our peer support team members. And you'll notice in my testimony, I don't talk so much about law enforcement here. I talk about first responders because this is a first responder program. And this certainly affects not only law enforcement, but firefighters and EMS personnel as well. And it's very important. I can't talk to you from a perspective of having been a peer support counselor, but I want to just share a little bit of information with you. In my 35 years of law enforcement, I started far enough back. We didn't have peer support. We didn't have anything. We were expected to just buck it up and come into work the next night. That worked sometimes. Sometimes it didn't. I can tell you that I went to funerals of 2 of my coworkers who committed suicide with a firearm after being involved in a critical incident because they had no out. They had nowhere to go. Back in those days when, unfortunately, if you went to your agency and said, I'm really struggling with this, I'm feeling suicidal, a lot of times you just lost your job. That was their answer to it. We've come a long way since then. I think it's important for you all to know that traumatic stress is a constant in the first responder world. And that can develop into post-traumatic stress disorder. Now, the disorder is something entirely bigger. But the way you avoid being wrapped up in the disorder is getting help early. And the first step and the early step is provided by these peer support teams. And as just relayed by one of the previous speakers, this is a buildup of things that happen. We all have stress in our lives, right? Sick children, issues at school with children, all kinds of things. And so those have an accumulative effect. And then you throw on top the professional related things, then that's a problem. And so by passing this bill, it will allow us to reach into those other things as well. So we're looking at the accumulative effect of all those things. And that's why our associations support this. We believe it's very important. Greg Smith mentioned the exceptions being, if you are talking about committing a crime or being a danger to self or others. If you look at page 3, lines 13 through 32 of the bill, there is a list of those exceptions in there where the confidentiality doesn't apply. This is very important for us. It's important for not only for the retention of our officers, it's also important because it affects our officers' abilities in every call they go to when they're suffering under these stresses. And we strongly encourage you to move this bill forward. And my last comment is that I will point out the House handled this on the consent calendar, if I remember correctly. And, or maybe that was another one. They did not. You're right. They did not because they made that amendment. I'm sorry. I'm getting my bills confused here. So with that, Madam Chair, I'll stand for questions.
Thank you. And we'll hear from our conferees in total and then circle back for any questions. Next, we'll hear from Lieutenant Alex Taylor, Kansas Highway Patrol. We already heard from him. Okay, thank you. Do we have any other proponent conferees in the committee meeting room or on WebEx? Not seeing any, then we will open it up for questions. First, noting that we have proponent written only testimony from Steve Kearney, Executive Vice President, Kansas State Troopers, Karen Blanton, ASAC, Assistant Special Agent in Charge, Wellness Coordinator, KBI, and Christopher Mann, Legal Advisor to FRST, First Response Support Team Midwest. Committee, any questions? Not seeing any, then do we have any neutral or opponent conferees wishing to testify? Not seeing any, then we will close the hearing on House Bill 2557 and open the hearing on House Bill 2632, which I believe is the bill that might have been on the consent calendar in the House. It's expanding membership of the Law Enforcement Memorial Advisory Committee to include a representative of the Kansas chapter of Concerns of Police Survivors to be appointed by the governor. With that, a brief from the reviser.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. As you mentioned, House Bill 2632 does come to you from the House after a placement on the consent calendar. It was requested for introduction by Mr. Klump on behalf of the three associations we've talked about in the Committee on Federal and State Affairs. That committee heard the bill, recommended it be passed and placed on the consent calendar. Final action, then the House passed it 111-0. And that brings it here to you. The statute that's amended in this bill is KSA 75-2251, which is the statute that establishes the Law Enforcement Officers Memorial Advisory Committee. You can see under current law, it has 10 members, and the bill would add an 11th member, and that person would be a representative of the Kansas chapter of Concerns of Police Survivors, appointed by the governor, much like the other members of the board or of the committee that are also appointed by the governor. And it would take effect on July 1st if adopted, and I'll be happy to answer questions.
Thank you. Committee, any questions? So this is a new advisory committee, or no? It's not.
Madam Chair, it is not a new committee.
Okay,
The
it's
statute
expanding the
dates-
membership.
Yeah, the statute dates to 1989, if I remember correctly. So it's been around for a long time, and they oversee the memorial that is out here on the State House grounds.
Great, glad to hear that. Thank you. Committee, any questions? Not seeing any, then we will invite proponent conferee Dana Evans on behalf of Kansas Concerns of Police Survivors. Please introduce yourself and welcome to committee. And the hour is running late, so if you can keep it to about 2 or 3 minutes, that'd be great. Thank you. And turn on your microphone so we can be sure to hear you. Thanks.
Thank you. I appreciate being here. I'm Dana Evans. I'm the treasurer of Kansas Concerns of Police Survivors, and we appreciate the opportunity to present this to you today. Are you familiar with Concerns of Police Survivors? Okay, well, then I'll take a moment to tell you what that is. Concerns of Police Survivors is a national organization. We have about 75,000 members. We also have 55 chapters. Kansas Concerns of Police Survivors is one of those chapters. What our organization does is we are a peer support group. All of our members are line enforcement, line of duty death survivors. We are family members and affected co-workers of officers that we've lost in line of duty. Our purpose is to provide emotional support to our members, also to provide financial support to our members to attend National Police Week in May. It is a week-long, it has 2 ceremonies for candlelight vigil, also for the memorial service from the National FOP for our officers to honor them. It also provides 2 days. Our organization provides 2 days of conferences on grief journaling, the journey of your grief. We also, as Kansas cops, we provide assistance to people to attend our national retreats, which are survivor specific. We have 14 of those that run the gamut from whatever survivor code you might be, a spouse, a sibling, adult child, a suicide survivor, these type of things. Kansas cops will also provide events to our survivors to bring those survivors together, as we have found that is a very good way to come together to honor our officers, but also to enjoy each other and tell stories about our officers that we've lost, because we don't want to stay mired down in our grief. As far as the memorial goes, our memorial is beautiful. It is such an honor for our officers, for our state to see that, for people coming to visit us, to go around and see our officers on that wall and know that they've given the ultimate sacrifice to the community. It is also a place of peace and comfort to us as survivors, because we can go and it reminds us that every day our officer got up and went to work. Every day could have been that day. Every time we came in contact with somebody with COVID or hepatitis C or a gun, those were all manners of which we could lose our officer. And every day we realize that we forget to think about that every day, that these officers go out. The traumas that they see on a daily basis, we may see as a regular person 2 to 3 if you have a lot of traumas in your life. An officer will see an average of 186 traumas in their life because of their job. So we as survivors are reminded of that when we come to our memorial. And we feel like we would be a great asset to this committee to bring that direct perspective to the committee when we're talking expansion as that is necessary, you know, in the years to come. When it comes to us trying to endeavor to bring our survivors in and provide an opportunity for them to come and see their officer's name on that wall and to come to our candlelight vigil here and to our memorial service in May or whenever that is held in the future. So we feel like we would be a direct voice for those survivors being on this committee, and we appreciate your opportunity, your consideration of this request.
Thank you very much for your testimony and for what you're doing for police survivors, the families, and for the memorial that you're visiting. It is a beautiful memorial. With that, then, if you'll stay around for questions, we might have questions. We'll invite Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. Please introduce yourself and welcome to committee again.
Thank you, Madam Chair, and thank you for listing the associations for me so I don't have to. My name is Ed Klump, and I'm here in support of this bill. This is another bill that we introduced, and you've heard the good work that the Kansas Concerns of Police Survivors do. This committee and this bill is not in any way aimed at any lack of work by the committee, the existing committee. They do wonderful work, a wonderful memorial out there. We recently expanded it not too many years ago, as you remember, because we ran out of space, and they just do a wonderful job at that. The reason this bill is here, if you look on page 1, lines 10 through 19 and 22 through 29, you'll see the list of the current members. And you'll see on that list that there is 7 law enforcement organizations represented: the Attorney General, the Department of Corrections, the State Historical Society. What's lacking is a voice of the family members of the lost law enforcement officers. And we, the reviser mentioned this bill, or the committee was formed in 1989. That was quite a few years before Kansas Cops was an organization in Kansas. And so it wasn't even on the radar at the time that this was formed. And we just believe it's the right time to add that voice as a voting member. I will tell you the committee does let them come in and have a voice in the committee now, but they deserve to representing the family members, they deserve to be a voting member of that committee. And that's what this bill is about. And yes, Madam Chair, this is the bill I was thinking about that went on the consent calendar, and we would appreciate your consideration of that here too. And I'll stand for questions.
Thank you. Are there any other proponent conferees wishing to testify? Not seeing any, then we'll open it up for any questions. Not seeing any, then do we have any neutral or opponent conferees wishing to testify? Not seeing any, then I want to thank both of you for coming and for your testimony today and appreciate you being here at the Capitol. With that, then we will close the hearing on House Bill 2632, and the hour is getting late, so we won't be proposing any possible final action on bills previously heard today, but please be prepared to do that next week. We are not scheduled to meet tomorrow, but we will be meeting on Monday, March 11th at our regular time and meeting room. So with that, thank you to everyone, and the meeting is adjourned.